And just some instructions about our panel. So 20 minutes for each speaker. Then I thought to organize the overall panel in this way. I think that we can complete all the speeches and then open the discussion. So I'll raise my open hand, show my 5 fingers, or alternatively throw a ball warming when you have only 5 minutes left. Okay.
Okay.
Only by this. I think I have to try to show the sharing of the. Okay, let me open because I don't see the arrow on the right of the bottom.
Mario, if you scroll with your hand to the bottom,
but there is a problem.
It should pop up
and
show share screen.
Yeah, but I don't see the arrow that allow me to select the function that can allow you to share your screen. Try.
Yes.
Could you try to share your screen?
Mario, I just enabled the function for presenter.
Oh, wonderful.
Are you using my screen?
It should work now.
Thank you.
Okay.
Wonderful. Okay.
Roger.
So, thank you, Ignacio.
Okay.
But it's a different function because yesterday I could habilitate all the speakers by the arrow on the right.
Yes, apparently there are different versions of Zoom. My Zoom is different from others. For instance, I discovered this trick, which I didn't enable Ivan. I just enabled everyone. So you should check that nobody intervenes sharing their screens.
Yeah, it's very strange. So, okay. So, I think that we can start because there are 6 and 4. Okay, so the title of this session is The Dark Side of Human Rights. And so I think that is a very interesting argument just because this dark side of human rights, in a sense, points out to the dark side of the universalization of the contents of human rights. What is very interesting is to ascertain if this is regarding something that is in the roots of human rights and the consequences of human rights. In any case, I'm sure that the speakers will show us a lot of implication of this ambiguity and the darkness, actually, of the human rights. So the first speaker is Fulvia Abbondante. She's a lecturer in public law at the Department of Law at the University of Naples, Federico II. She has been teaching information and communication law since 2014 in the same university. And she has published various articles on information and communication law, gender equality, multiculturalism, freedom of speech, and freedom of religion. She involved in national and international research projects. So, dear Fulvia, I give the floor to you. Now our virtual law, yes.
Okay,
so,
thank
let's
you.
Start, please.
Thank you very much, Professor Ilka.
Sorry, I have to declare officially the title of your speech is Populism, Democracy, and the Legislative. Okay, let's start. Thank you.
Thank you very much, Professor Ilka. I am very grateful to organization committee to invite me to this interesting conference and all participants and attendees. I hope to share my presentation. Okay. My presentation starts from 2 key points question. What is democracy? What is the populism? Apparently, both of these terms are easy to explain, but they show several nuances, so that it's impossible to give a unique definition. Democracy is an ancient government system. However, today it's probably better to speak of a constitutional democracy, which is the result of the combination of liberal democracy and social democracy. Contemporary liberal democracy, moreover, do not represent a conclusive definition of democracy, as Colin Crunch observed, because they display historical contingent force. There are, though, some uncontroversial points that characterize the constitutional democracy: separation of powers, rule of law, guarantee of fundamental rights. The term populism has not a clear definition as well. As Lacleur claims there is not an exclusive and pure populism, but a variety of meanings which depend on the movements and the parties that are in opposition to the established powers. Democracy and populism, however, have points in common. Some scholars point out that populism is possible only where is democracy. There is a strict connection between them. Many and Sorel argued populism uses the same words, same mythology of democracy, by an extremistic way. The consequence of this approach is a reinterpretation of a modern conception of sovereignty of the people. Both democracy and populism evoke the idea of people, and in particular, how people should be governed. What changed is the very idea of the people. Assuming a simplified populistic pattern, the people is split into parts, authentic people and the others, according to blocker, elite lobbies, or immigrants, Muslims, and so on. So that the sovereignty belongs only to the presumed authentic part of the people. In the constitutional democratic conception, the people is considered in a pluralistic way, not homogeneous and without any moralistic approach. Eventually, the division in a democratic view is between majority and minority, but this distinction is an essential element of representative democracy. Generally speaking, populism is a movement which criticizes representative democracy, shows intolerance toward constitutional limits, denies the importance of intermediary bodies. The only legitimate expression of a people is a charismatic leader, able to interpret the real needs of the real people, and the only way that the leader and the people can communicate is to direct, or even better, immediate democracy, facilitated by the web and the use of social network. In one word, populism is not against democracy to court, but shows hostility towards liberal democracy. It's important also to point out that this kind of populism is classified as right-wing populism, while it is possible to identify another kind of populism more attentive to the involvement of people in decision-making. This distinction is significant to understand how these movements take a stand on human rights. Paradoxically, right-wing populistic movements use and abuse tools of constitutional democracy to change democratic order into authoritarian order. As Tashnet points out, the decision maker conforms to some general procedural requirements and implements decision through, among other things, independent courts. But decision maker is not constrained by any substantive rules regarding, for example, civil liberties. In a clear way, Tashnet affirms that the criteria of generality, publicity, and abstraction of law are formally respected, but no substance of constitutionalism. Once gained the power through free and lawful election, they proceeded to change in a direct or indirect way by deleting check and balances from the Constitution, above all neutralizing the role of a constitutional court and judge, that is, the counterpower able to stop the illiberal trend. It's difficult to simplify experiences so different, but it's clear that populism leads to an authoritarian evolution in countries with very various traditions. Poland, Hungary, Turkey are involved in this process, but also most mature democracies, such as USA during the Trumpian era and President Modi's India, should be classified this trend. It is important to underline the connection between the right-wing populist movements with the conservative and traditional vision of religion. As Rosenfeld and Mancini observed, populist movements use the religion to discriminate real people from the others. Religion, in fact, works a strong argument to empower the identity and sense of belonging to a specific community. In some cases, populism incorporates nationalism and the use of religion for the purpose of neutralizing external enemies, other religions, as it happened for Muslims, but also internal enemies, secularized elite. A clear example of this tendency is a severe modification of fundamental law in Hungary in name of guaranteed value of Christianity, and some very restrictive legislation in Poland. How does this connection between populism and religion affect human rights guarantees, in particular women and gender equality rights? As Mancini and Palazzo implied, there is an obsession of a liberal actor with the topic of gender. That is understandable. Issues related to sexuality, family, and reproduction are crucial when speaking about identity. Recently, Orban has left the European People's Party, advocating the traditional basis of this party, that is against every form of tolerance towards migrants, multiculturalism, and LGBTI rights. It is possible to identify similar actions to neutralize the women or gender equality. First of all, through the modification of precedent and most favorable legislation, acting on appointment of judge, preventing from the development of association which promotes women and gender equality. It is an ambiguous phenomenon, and it is possible that the action converge or not. Moreover, it may be that the populist part is against only homosexuality or transgender, but not against women. To understand the complexity of this issue, it can be interesting to evaluate the ambiguities of a populistic narrative about the instrumental use of gender rights to support racial and xenophobic politics against particular Muslim minority. Clear examples of this incoherent approach stretch from Europe to USA. The different position about equality of women in domestic context. The patriarchal vision of women is strictly connected with traditional hierarchical view of the family. It collapses though when criticizing migrants for their alleged lack of respect of norm about men and women equality. It has Trump's approach. The position of Alternative für Deutschland, which is guided by a lesbian woman. She is against abortion and other policies allowing balances of family and work. In this sense, the populistic movements have reinterpreted in a new manner the concept of human rights, orienting the cognitive frame to the specific cultural context of each country. There are several cases in which anti-gender in very broad sense policy is expressed at the legislative level. In 2017, Trump's executive order introduced the global gag rule that prohibits foreign NGOs to receive US global health assistance from providing legal abortion services, or referral will also barring advocacy for abortion law reform, even if it's done with the NGOs own non-USA funds. In January 2021, Biden rescinds this controversial order. At the beginning of this year in Poland, the law prohibiting abortion is entered into the force. In Hungary, since December the 1st, 2021, Equal Treatment Authority, a very active agency in protection of gender equality, was abolished and competencies were assigned to Ombudsman for fundamental rights. This measure was justified by the government through the need to make the action of the state more efficient in fight against discrimination. On the contrary, this change is a further regression in the protection of this principle, since the Ombudsman in Hungary has long been a body closely dependent to executive power and no longer able to perform its functions with impartiality and effectiveness. At the moment, Italy is under discussion the DDL ZAN, measures to prevent and combat discrimination and violence for reasons based on sex, gender, sexual orientation, gender identity, and disability. But right parties with the populist approach are against it. At the international level, Poland and Turkey withdrawn from the Istanbul Convention, while Hungary has not even ratified it, claiming that convention conveys values openly contrary to Hungarian tradition. Recently, Poland and Hungary obtained the removal of promoting gender equality expression from the joint statement of 27 European leaders at the Porto Summit on defining the Union's social policy agenda and during the approval of the budget 2021-2027 and the next generation plan, they prevented from imposing conditionality because of the violation of their traditional values. Well, it's important also to understand the role of a national Supreme Courts. It's not easy to simplify a variety of situations. For example, in 2018, Hungarian Supreme Court has recognized the right to change the name on documents for non-Hungarian transgender citizens. However, with the Article 33 of organic law in March 2020, Orban has repealed this resolution, stating the impossibility of modifying the biological identity. Differently, the Constitutional Court in Poland declared unconstitutional the law about therapeutic abortion, opening the way to prohibition of abortion to occur. Supreme Court of USA had a different approach time by time, generally tended to privilege privacy or classify reproductive rights of women as a part of a broader right to health. But recently, Barwell versus Holy Lobby, the majority of justice concluded that the Religious Freedom Restoration Act prohibits the federal government from requiring that employers who provide health insurance benefit to employees include comprehensive contraceptive coverage as a part of their health insurance plans. The religious objection prevails on freedom of reproduction. Some considerations are necessary about abortion in USA, especially after the leading case Roe versus Wade, where the judge recognized the legality of abortion. Many states have introduced very restrictive legislation or created many obstacles that prevent women from performing abortion. In June 2020, case Medical Services versus Russo, the Supreme Court stated that Louisiana law posed a substantial obstacle to women seeking an abortion. The Supreme Court declared the unconstitutionality of the law since it offers no significant health-related benefit and consequently imposes an undue burden on women's constitutional right to choose to have an abortion. At the moment, it is pending in front of a Supreme Court a case of constitutionality of abortion law in Mississippi, likely to overrule the president, which seems more and more likely to happen after the appointment of Amy Coney Barrett, ultra-conservative judge, by former President Trump. In Italy, the Constitutional Court has played a very important role in affirming the abortion reproduction rights, recognizing the right to agreement of partnership for same-sex couples. In 1975, the constitutional judge eliminated the crime of abortion. Parliament approved 3 years later the law that allowed women in specific conditions to interrupt the pregnancy. With various decisions, in Italy, Supreme Court has reinterpreted Law 40/2004 in closer conformity with the Constitution. At the moment, the presence of a very strong right populist movement with a high rate of consensus, Fratelli d'Italia and Lega, are putting this achievement under stress, as I mentioned above about DDL ZAN. Some final remarks. What will build the future of human rights in the populist era? Pandemic has shown the limit of this ideology. See Trump last year and Bolsonaro at the moment. But influence of this movement at domestic and international level are very strong, as I have tried to demonstrate. In last year, gender human rights have been taken for granted. But as Giambattista Vico argued many centuries ago, human history is a continuum to recurring cycles in the history of civilization. The important thing is not to forget how the constitutional democracy is an imperfect way to govern, but as Churchill remembered in a different way, the best that humanity has created. Thank you for your attention. I think I stay in time.
Yeah, you said perfectly in time, dear Fulvia. Wow, wonderful. That's very interesting. But I'm always bewildered by the strange contents of the court's decisions about human rights. The game of universalization is so ambiguous. It's so multi-directional.
Yeah,
It's
absolutely.
very, yeah. I remain always with some doubts about this, and I don't know what could be our future on this. So we can pass now to the second speaker, and is Ivan Samut, is a resident academic within the Department of European and Comparative Law at the Faculty of Laws at the University of Malta, where he taught and researched since 2005. Prior to joining the university as an academic, he practiced law in Malta and acted as a consultant in EU law. He was also employed with the European Commission for 2 years. His teaching and research interests focus in particular on the EU internal market legislation, justice and home affairs law, competition law, European private laws, from a comparative perspective in European private international law. He has published various articles in multi and international peer-reviewed journals, such as European Private Law Review. Ivan is also the author of a monograph entitled Constructing Modern European Private Law, a hybrid system published in CSP in the UK, and as well as an editor in a number of edited academics. His presentation has this very fascinating title, The Dark Side of Human Rights Procedure. It is a breach of substantive human rights law. Dear Ivan, the floor is yours. Let's start, please. We can hear. You have to activate the microphone.
Okay, thank you. Thank you. Okay, so if you look exactly at the title, you notice that I'm asking a question. And the idea of this question came from a practical case where I was involved, a practical human rights case in front of the Maltese courts, where one of the main issues was the right of fair hearing. And it was clear that the Constitutional Court was not following itself the right of fair hearing. So the Constitutional Court in Malta was basically analyzing and judging another court, local court, about the procedure. And then itself, it was technically in breach. So the problem that I was thinking is, why are we claiming human rights law in a constitutional court where the procedure itself is creating hurdles to affect the substantive human rights law? So this is basically the program, the idea. If you look at a textbook of human rights, you notice how many rights, how good they are, how many cases, how much the individual is protected. Everything is nice and glittering. In practice, you find sometimes a completely different world. Okay, I think it's better if we move like this. Okay, so in my presentation, I'm going to focus on specifically on three angles. I'm going to talk about the European Court of Human Rights in Strasbourg. I am going to mention some local aspect of Maltese constitutional court, which could be used as an example of any other country constitutional court. And then at the last, I'm going to have a comment on the European Court of Justice in Luxembourg of the European Union. And basically, I'm just using these three examples just to give you a hint of what is coming. So first of all, human rights is not without exceptions. As you know, I don't know whether you are aware, but last year, after the COVID pandemic basically came upon us, some European countries even applied for the exclusion of some rights from being enforced during the pandemic. So for example, we have the right to assemble in public, but because of the pandemic, we cannot. So basically, they applied for an exemption, which is possible under the convention, so as local laws that might infringe human rights would not be caught up by the constitutional order. And again, Article 6 is one of the most common cited provision of the European Convention. Most cases, even if they don't deal with fair hearing, will bring up the issue of fair hearing. Then the issue of right to life. Right to life could be involving family reunion in case of migrants, for example, or in cases of family separations, custody, etc. And very interesting, Article 13. Now, it is interesting because this effectively gives you the right to have an effective remedy, but very often in human rights cases, the effective remedy is elusive. Okay, so I was imprisoned for a number of years. My imprisonment was found to be in breach of human rights. What happens? I get money, I might still remain in jail. Then there are some orders which are not respected. Take even the European Court of Human Rights. I don't know how many orders I found asking the Russian Federation, the Russian government, to release Alexei Navalny. I think Alexei Navalny, as we speak, is still in prison. I think even recently his party was declared a terrorist organization. So see, we go to courts, we go to Strasbourg, and we still end up with nothing in hands. So the idea is human rights a fantasy that you find in the academic world? In the real world, what is happening? How are we going to co-enforce our real effective rights? If I am an innocent person, or if I shouldn't be in prison, what should I do? How does the state guarantees that I am not imprisoned? If I am in a custody battle and I am fighting to see my children, for example, what does the state, the court, the executive police, whatever, what are they doing for family reunification? And the list goes on and on. So over there you see a small picture of a dinosaur. Could be a friendly T-Rex. Well, I think it is a friendly T-Rex because if you look carefully at the dinosaur's head, you find that there are no teeth. Imagine a T-Rex without teeth. So this is the problem that we may be dealing with human rights in some cases. So very often scholars, lawyers, and even the victims themselves look at human rights legislation as the ultimate savior to their problem. Okay, if I lose my case, I can go to the Constitutional Court. If I lose the Constitutional Court, I can go to the Supreme Court or to Strasbourg. So prisoners want to gain freedom through human rights. The general public feels that it is better protected. But effectively, who is going to enforce? And then if you win, what is going to be the ultimate conclusion? You might win the case and you don't get an effective remedy. So this is the anticlimax that you may face if you look at human rights procedure. The problem is the procedure. Why? Because some courts may not be accessible. Take, for example, the European Court in Luxembourg. How can you challenge EU law? There is a procedure, which I'm not going into great detail, which is Article 263 of the Treaty of the Functioning of the EU. This provides for an individual the possibility of challenging a decision. But, you know, a decision is not any decision, it must be addressed to you. So if I have an interest in a decision addressed to a group of parties of which I have an interest, but I'm not individually concerned, I might not get the remedy. In order to go to Strasbourg, you need to satisfy the Article 47 rule. And then even in the National Court, okay, I mean, Article 6, the right of a hearing, which can mean many things, could be even mean accessibility to the court, okay? It could mean that the judge hears the case properly, not you file an application, and then the case starts being heard 6 months after. Is that a breach in itself of human rights? Of course, most courts are slow, but there is a limit as to what is acceptably slow. I mean, if you are fighting a court case about property, well, I mean, if it takes a year or two, I think the property is still going to remain there. But if you are fighting, for example, for freedom, every day, every second that you stay in jail is a minute lost from your life. So this is the anticlimax. So human rights, where are the human rights? Let's look at the local court perspective first. So in Malta, if you feel that your human rights are breached, you can go to what we call the first hall of the civil court, which is the Constitutional Court of First Jurisdiction, and then ultimately you appeal to the Constitutional Court. This is a normal court, which is presided by one judge. In Malta, all courts, all first instance courts are presided by one judge. The Court of Appeal would be presided by 3 judges. So what happened? Imagine you are going complaining about fair hearing. So you file an application. Normally, constitutional applications are processed quicker. So the first hearing might happen a few days after you file your application. But then when you go to court, you see that you have a judge whose caseload for the day involves 30, 40 cases. And then at noon, there will be some constitutional cases. So the judge is shifting from human rights to civil, commercial, everything is set up together. All the others are fighting for a slot. This is how it works, unfortunately. And you are arguing for a fair hearing, and you may end up not even getting a chance. And then obviously, there are, yes, written hearings, but again, that takes time, and delays. Expert reports, again. In one particular case, for example, that I was involved in myself, the Constitutional Court took 1 year to hear the viva voce, the expert of a case who had submitted the report a year before. Is that a violation of Article 6? Well, it is. And ironically, at the end of the case, the court found violation of Article 6 of the other court. But in finding a breach of Article 6, the court itself committed a breach of Article 6. Obviously, the court is not saying you, I am committing a breach of Article 6. And then you appeal to the Constitutional Court. What happens in the Constitutional Court? Another 5 months waiting. Of course, you have 20 days to appeal, but you have another month of waiting. Now, again, this depends on a lot of things. And in fact, one of the next points that we are going to come up with very shortly is this an effective remedy? Just to give you an example, for example, imagine in family court, okay? And you want to notify your ex-husband or your ex-wife about a degree involving, let's say, a children's activity, for example. In Malta, probably in some countries as well, there are 2 ways of how you can do notifications: by registered post to the court, or you send a court martial. Sending a court martial is easy because the court martial will go to your spouse's residence. But if your spouse is there, the procedure stops there. And if you don't notice that the notification was negative, and you don't do it again, this process, which should take a few days, may end up taking months. So gone is the child's activity. So obviously, I mean, this is the reality. That's why I put the picture of a pigeon. And probably if you notify the other party with a pigeon, that would be even faster. Now, procedural hurdles to take a case to Strasbourg. Now, we have the idea in Malta, which is wrong, that to go to Strasbourg, when I say Strasbourg, I mean the European Court of Human Rights, you need to exhaust the local remedies, which we take it to mean that you need to have filed a case in the Constitutional Court, lost it, appealed to the Constitutional Court of Appeal, lost it again, and then file to Strasbourg. Now, obviously, as I said, the procedure might take so much long that any remedy that you might have been seeking would become ineffective. It would have become irrelevant. Imagine you want to, for example, have access to your kids, and you spend 10 years fighting in your court to have access to your kids. By that time, by 10 years, probably your kids will be grown-ups. So you'll never go to have access to your kids. So obviously, exhaustion of local remedies means that if the court system is not working in your own case, it is not going to give you a satisfactory matter, then you can go on to, according to Article 35(1) of the Convention, you can go directly to Strasbourg, so that the Strasbourg will obviously listen or hear your plea. Okay, then there is also the issue of the 6 months delay. And ironically, I have found pleadings whereby in one part of the pleadings they argue that the person hasn't exhausted the local remedies. On the other hand, they argue that now, from the first fringes of human rights, the 6-month rule have elapsed, which is obviously not the case, because there have been case law of the European Court which said that this is, if in case of a continuous breach, I mean, then the 6-month rule would apply. So if you were to look very briefly on the admissibility criteria, you'll find that it is not easy even to access Strasbourg. From statistics that I've seen, I think there are around 1,000 or even more applications per month to Strasbourg, yet less than 5% end up with a judgment, probably even less than 5%. So as you can see, having a court just made up of one judge per member state of the Council of Europe, with a population of close to 1 billion. I mean, there's the European Union, obviously there's Turkey, there's Russia, there's Ukraine. I mean, is this enough to satisfy the human rights infringes? Probably it is not enough. So these are some examples of human rights cases involving parental alienation. Parental alienation is, for example, when a parent alienates a child from another parent without a just cause. I'm working on a project at the moment, and I am dissecting these judgments. So basically, these judgments are about a person, a parent, seeking reunification with another kid. And in most of the cases, you will find that although the alienated parent practically always wins, the effective remedy does not exist. The court will award you a few thousand euros, and you end up with a few thousand euros. So is this the human rights that we are seeking? Does the European Court has the power to give you a solution? And the answer is no, because the solution, the European Court, is an international supervisory court, and it relies on the member states. Okay, there is the famous Papakodopoulos directive. Someone from Greece might read it even better. I mean, this has to do with the former Greek monarchy, okay, which obviously is no longer, in office. And basically, the court said that in this particular case, the legal obligation ideally should put an end to the breach and make reparation for its consequences. If you look at the red words, it gives you exactly what I mean. So if there can be restitution integrum, then the court should go for it. But very often, the Strasbourg court does not give you restitution integrum. It gives you money. It gives you compensation. Obviously, money does not solve everything. And this is the case from my country, Constitutional Court, 2012, so only 8 years old, more or less, where the Maltese Constitutional Court and the Maltese government said they have complied with Strasbourg by paying compensation. This was a case where a person fought under Article 6 about the right to appeal. Okay? He won the case in Strasbourg. He got compensated by 5,000 euro or 6,000 euro. The appeal never happened. So why did you go to Strasbourg? You don't go to Strasbourg for the 6,000 euro. You go to Strasbourg in this particular case for having the right to appeal on the substantive matter. So as you can see, the Maltese Constitutional Court has this opinion. I give you money and shut up. As if money is going to solve the problem. I mean, and effectively, most Strasbourg judgments are effectively about money. If one were to change the subject completely and go to the Charter of Human Rights, you find that the Charter is very much exhaustive. Compared to the European Convention, the Charter is very much exhaustive, and there are...
there are even 5 minutes left.
Yes, I am almost done. But basically, there are several more rights that are found in the Charter of Human Rights, but this only applies in the field of application or implementation of EU law. So if I have no EU law issue, then the Charter is just a nice document which we can discuss, but it will not lead to any effective remedy. Okay, so member states are bound by the Charter, but the Charter very often doesn't apply. And finally, the famous Article 263, paragraph 4 of the TFU, the right of the individual, okay, to challenge any EU decision. Okay, this is the pre-Lisbon Treaty version and the post-Lisbon Treaty version. Basically, an individual, it's almost impossible if you look at the case law, it's almost impossible for an individual to challenge a decision of the EU in the EU court, which is not addressed to that particular individual, because individual concern is interpreted as being a member of a closed group. A closed group means not that you are, let's say, part of a group of farmers, but you are a part of a closed group of farmers who happen to suffer different from all the other farmers. So effectively, to be individually concerned, I mean, generally speaking, the decision must be addressed to you. So the right of effective remedy is practically almost non-existent. This is one of the cases. The final slide that I want to show you is where are the teeth? Remember the dinosaur metaphor? Well, I think there have been improvements, so I don't want to be too negative. Okay. In fact, the European Court in Strasbourg, for example, even adopted the procedure very recently of a committee where judgments go to a committee instead of the normal chamber of 7 judges. A committee is a normal court of 3 judges. It's quite effective, it's quite faster, and some cases takes place are concluded in much shorter time. Use of technology. We've had the discussion earlier on about how good Zoom is to reach the words. I mean, even in 4 courts, courts must make use of technology, because through technology, human rights can be better enforced. Again, more investment in judges, not only in technology, but also in human resources. I mean, probably the European Court of Human Rights needs more judges. 1 judge per member state, 40-something judges is not enough. Obviously, more political correctness. Money doesn't solve all the problems. Money cannot buy human rights, okay? So obviously, we need to implant the teeth to the dinosaur so that human rights would bring an effective remedy to the real life of the individuals. And that is the end of my presentation.
Thank you, Ivan. Thank you so much for the presentation. That shows us the dark side of the procedure as part and parcel of human rights protection. Or at least
very brief, but anyway.
Yes, it seems that for the institution, it's easier to get the enemies, in this case, individual claiming for their rights for exhaustion, than defeating them by fighting. One wonders about the procedural agencies are nothing but the other side of the coin, or a struggle for the semantic discrepancies, the semantic divergences about the contents of human rights in many cases. And this is only a dissimulating tool, so to avert the necessity, the opportunity from another point of view to consider some very difficult, some hard cases, also from a political point of view. Okay, thank you so much for your presentation. Now we pass to the next presentation, and we have Kyriaki Tovidi. Kyriaki is a senior researcher and head of the researcher cluster on culture and diversity at the European Center for Minority Issues, Flensburg, Germany. She has lectured extensively and researched in the areas of public international law, European law, human rights, and comparative law. Her research interests focus on diversity management and minority protection rights and mechanisms with a special interest in religion. She is the author and the editor of a number of volumes and articles. Her latest monograph focuses on the right to different comparative religious diversity in education. And at the ECMI, she is currently researching on minority identity and digital governance, as well as on the intersection of minorities with social movements. Her presentation is titled Deconstructing State-Centric Legal Spaces in Europe, the Legacy and the Implication of European Courts of Human Rights Mola-Saley case. Dear Kyriaki, the virtual floor is yours.
Thank you. Thank you very much. First of all, thank you, Chair. Thank you to the organizers. I hope and trust you can see my PowerPoint. A first remark, there's a slight change in the title. The paper has matured since it was submitted. So now I am more concise in the sense that I focus on religious pluralism and state-centric legal spaces, and you're using the particular case as my focal point. And I will be picking up a few of Fulvia's points. So there is some coherence in I think, our thoughts and our reflections. Now, let me first start with a comment that the chair himself made, and I think is a very valid one. Ultimately, I don't think that we are discussing something new here. I think we are looking at an old question. And as far as I'm concerned, that question vis-a-vis the universality of human rights has a particular configuration, which is the following: should religious and custom-based legal orders be tolerated by liberal and democratic states? And how is the balance struck if and when that happens? This is particularly so because religious pluralism and public religion more generally seems to challenge in more than one ways our conception of individualized right-based liberalism. There has been a lot of thinking already happening since the early 2000s. I have put down for your reference two sets of theoretical frameworks that have become very popular. Ben Habib, 2002, when speaking of multicultural legal arrangements, so how do we coexist in our societies with difference, spoke of a model where you need three conditions: egalitarian reciprocity, voluntary self-ascription of the minority cultural members, and obviously the right to opt out. Similarly, Ailet Shahar, a year earlier, spoke of transformative accommodation on the basis of shared power, essentially, putting forward a very similar paradigm with a right to exit, and where power is shared between minorities and majorities, power in the sense of shaping the coexistence and coordination of norms. I think what we have not studied that much in this rather old topic is how members of religious minorities, at least in the West and more specifically in the European context, are starting to realize and act as rational thinkers when they choose to put in claims. They no longer act exclusively as believers, but also have their own agency. Sorry, this is going too fast for me. Okay, so all of this discussion for this particular paper is transposed in the framework of a case that arose and started off from Greece. Now, Greece has a very interesting situation. The legal system, the state legal system, recognizes elements of Islamic religious law formally. So it's not an informal system, for historical reasons related to the Ottoman Empire, and by mere, acknowledgement of the fact that we have an approximate 5% of our population that has a different belief to the majoritarian belief. Now, in that, if you want official recognition, the central role is played by muftis. Muftis are what in other Islamic inspired systems role would have been played by Qadi, but a mufti in the Greek case is someone who is responsible to adjudicate on family law matters based on Islamic law. But it's always a he, by the way, does so without standardized rules of procedure, with no possibility of appeal, with a requirement, however, of finding or seeking an enforceability degree from the official state courts of first instance, just, to keep a very superficial compatibility between the constitution and what is decided in those Sharia-inspired adjudicatory fora. Now, gradually and over the years, Greek Muslims are gaining in legal consciousness, and they are also understanding how to use the possibility to seek and make fall decisions of religious courts by virtue of the violation of the Greek constitution, or by virtue of the fact that these decisions are ultra vires or even are misinterpreting the law. So I think this is a beginning of a story about agency, but obviously one that requires much more research and empirical data. Now, in the Greek case, and before these muftis, legal assistance is not required. Obviously, that works to the disadvantage of the more vulnerable populations, vulnerable in the sense of, for example, education or even gender. There is a penalizing effect from a gender perspective due to the informality of adjudication. So a classic example, just to give you a measure, is how maintenance is calculated in cases of divorce. We have records from the mid-2000s, I would say, of amounts being between 100 and 300 euros or something like that, which is extremely low. And this is because women are not able to substantiate, and defend their positions within those fora. And then on top of that, and that's a great particularity, we have a very ambiguous role that state courts are taking when they're dealing with questions of compatibility of the decisions of these courts with the Greek constitution. When they are exercising this overview, they have not been consistent. They have found excuses like the fact that Sharia law is territorially applicable. So territorial jurisdiction is a way to, throw out a case. And sometimes they have even produced inconsistent findings as to what these muftis are competent to hear. So all in all, we're looking at a very fuzzy picture. You should add to that the political and security dimension that stems from the relationship between Greece and Turkey, and how the state courts filter all of that environment, and how that is obviously then transposed into their decisions and findings. As an example here of this, if you want, of this artificial environment, ambiguous environment, is the legal technique that has been traditionally used, and which is also, by the way, at the basis of the Molla Sali case that I will come to in a moment, to avoid reviewing, for state courts to avoid reviewing mufti decisions. Sharia is treated as special law akin to international law, which under the Greek constitution takes primacy over national law. So this is a way that especially higher ranking courts, not courts of first instance, have used to avoid exercising overview over Sharia decisions. Now, let's come to the case briefly. This is the Molla Sali case is a case about succession. The facts very briefly are this: we are looking at a couple, Greek citizens of Muslim faith without children. The husband decides to opt for a notarized public will, making sure that his wife receives everything or is entitled to receive everything after his death. However, that doesn't happen because upon his death, the sisters of the deceased actually go to a mufti and claim the application of Sharia law, whereby they would be entitled to inherit 2/3 of his property, as opposed to the rules of the Greek civil law, which would privilege obviously the wife in the absence of ascendants and descendants. This in a climate where usually Muslims in Thrace, where that particular minority is placed, opt mostly for notarized public wills. You can read here exercise of an agency, or want to deal with their property through parental donations while parents are still alive and when they have obviously children. So the Court of Cassation decision of 2013, the Molla Sali one, is specifically denying the right to the widow to obviously enforce the public will, which was based legally on Greek civil law, and force the application of Sharia instead. And that is the apex civil court, by the way. This is the setting of the whole discussion of the paper. And the paper obviously looks at it from a diversity management perspective, not so much from a strict conflict of rights perspective, but how do we deal with situations like that? And what happens and what is the role of the state when there is conflict? As a side remark, just to highlight a little bit what was also discussed in other panels, there was a change of law whilst the case was being heard in Strasbourg, because Mrs. Sally took the case all the way up in the context, I think, of what is a good example of strategic litigation. But in the meantime, the Greek state in 2018 changed the law and made the Mufti jurisdiction optional, unless the parties obviously agree otherwise. So we're looking not so much as to the impact of the case per se, as to more rather than into the configuration of the different if you want, dynamics in place. So what are the implications of Molla Sali? The first level, if you just read the decision, you will realize that according to the human rights framework that we have in Europe, as it is reflected in the European Convention, Article 9, which is on freedom of religion, does not impose a duty to comply with religious law. So this is the starting point. But the question that the case doesn't actually answer is, at which point is the state supposed to intervene when rights and freedoms are infringed as a result of the application of a religious system of law, system of norms, such as Sharia. We also know from previous case law that of the same court that the state must act neutrally and impartially when exercising regulatory power. However, where things become complicated is this point. In earlier case law, the same court said that Sharia is incompatible with fundamental principles of democracy. But in Molla Sali, the configuration changed. And this is why I think the case matters, not only for the questions, the small number of questions it answered, but also for the ones that it didn't really provide, comprehensive legal guidance on. So here, Molla Sali is a case about the religious minority applying Sharia historically, as opposed to, a post-immigration context where we have a recently or relatively recently arrived minority in a Western context or Western country. So it's not an immigration case. The second point is that it is a case where the state is forcing the application of Sharia and not the community or the member of the minority religious himself or herself. Even more interestingly, from a minority perspective, this is a case where the state, Greece, justified its practice as a minority protection measure. So here it's becoming almost surreal, if I may say. It is a paradoxical case, but one which is very interesting because it started a given discussion, and the discussion is the levels of discussion that it started are the ones that I've listed below. How self-identification matters, and it matters both individually but also collectively, individually mostly as agency. So don't forget that the case was essentially about money, not about whether someone is a good Muslim or not. It was about inheriting property. The second interesting finding here is that states can and do grant special status to religious minority communities now with the approval of the European Court, subject to two, obviously, conditions. One is the will of the parties involved when they wish to apply religious norms, and obviously the protection of public interest. But what the case didn't tell us is which would be the criteria on the degree and preconditions for Sharia to be compatible. It just says that it can tentatively be compatible, but not how and under what circumstances. So the gaps in and through Molla Sali for the discussion that I have undertaken in the paper are these. It might be a positive thing to say that this is the first attempt at the European Court of Human Rights level to start thinking about how does one balance competing interests in conditions of plurinormativity. But of course, it is just the beginning. It doesn't tell us anything about the perennial and I think global concern as to what constitutes consent and peer pressure in communities like the ones that Molla Sali concern. It doesn't tell us anything about public interest and the contours and confines of the concept from a state perspective. It can be very well subjective, and the European Court, as a side remark, is good at allowing subjectivity through the margin of appreciation. And then it does not obviously take account of a lot of the cultural, factors in a discussion like that. For example, I've listed here some. In some Muslim communities, maybe not the ones in Thrace, but I'm sure it happens elsewhere in Europe, using state courts, it definitely happens, for example, in India, by the way, use of state courts is perceived as an act of defense. You don't go to the state to solve community-based issues. The second point is how does the state manage to enhance communication between its own bodies, including the judiciary, and non-state, including through the judiciary, sorry, with non-state legal systems. And then the final point is how legitimate are Sharia adjudicatory mechanisms. Here, a non-legal argument, and I think a pretty sociologically convincing one, is that these kinds of mechanisms, both the ones that are state endorsed and the ones that are not, actually rely on their I wouldn't say clientele because that's not the right word, but their audience. If they are not perceived as legitimate among the community, and if they're not used, then they lose obviously their standing and usability in the context of adjudicating disputes within communities. Now, the second part of the paper deals, and I'll be brief with that, with a brief comparison between the Greek case and the UK case. And now this is rooted on the fact that these two cases, the Greek and the UK scenario, were highlighted in a recent report of the Parliamentary Assembly of the Council of Europe on Sharia in Europe. The report is dated in 2019, if I'm not mistaken. So there is a comparison. The comparison is obviously of a certain value, but not comprehensive. Major difference between the two cases is that Sharia in the UK is not part of national law, so Sharia councils are not courts in the same way that the Mufti would be in the Greek scenario. And these Sharia councils, according to more anthropological and socio-legal research, avoid conflict with civil law. They are cautious. They try to act only as authoritative interpreters of religious law. But overall, they're still found imperfect institutions, among other things, because of gender concerns. They are imperfect for a number of factors and reasons, and these are listed below. For example, because when it comes to marriage, there are a good number of unrecognized marriages in English law, because they do not answer the question as to how people that resort to those instances, to those councils, self-identify, and how do they perceive their community standing. And that obviously leads us all the way back to the concept of consent. These are instances that lack in transparency and obviously have a relatively poor record when it comes to the applications of norms that they use from a gender perspective. So all in all, Sharia operates as a governance dilemma in my reading, because it doesn't allow us to have a comprehensive view of autonomy and the full span of the risks for vulnerable groups, apart from the gender one, which is starting to be more comprehensively mapped, because it also showcases the reluctance of states to become involved, even when they know and they see of violations of other fundamental rights. So typical clash of rights scenario of religious freedom versus equality. Sharia is also governance dilemma because it is not compatible. Sharia as a system of norms is not compatible with our Western based understanding of legal systems and legislation. There was a very interesting panel yesterday that discussed precisely that point. Sharia's legislation is the exception rather than the rule. And ultimately, the application of Sharia in Europe is an informal matter. It is a question of how mostly immigrants deal with their faith and their belief vis-a-vis God. And we don't really know how that happens. We don't know how Sharia is practiced and perceived in a comprehensive and comparative way. And then there is peer pressure, and that is the consent thing. But peer pressure cannot be separated, in my view, from agency. So how people use rules of Islam and what their aims are and what they use them for. Do they use them to get more money, or do they use them because they firmly believe in them? And all in all, Sharia has a very different philosophy over extrajudicial dispute settlement, which is not the Western-based conception of state. So all of these factors, if you want, have two sides, and I think we should acknowledge both of them if we are to manage difference in society. Now, going back to Sharia councils in the UK, here's an interesting observation. The users of Sharia councils are more than 90% women, and these cases for the most concern divorce. Now, one would legitimately ask why, if discrimination is so widespread, gender discrimination is so widespread. And
sorry,
then
exactly, only 5 minutes left.
Yes, thank you. The reasons that I was able to locate are the following: because they hold deeply religious beliefs, because of family requirements and social standing requirements, because, for example, when we talk about marriage, they have not registered their marriage civilly, so they're only religiously married, because they are not aware of the requirement of a civil divorce when they have done both a religious and a civil marriage, or because simply they're not able to pay for a civil divorce and they want the satisfaction of knowing that culturally they are divorced. Now, when it comes to regulation, I think the current literature makes a basic distinction between two scenarios. States either allow those communities to self-regulate. This is less encouraged because it is problematic for both the state and those communities. And then the alternative is obviously for the state to intervene, and it can intervene through regulation in any form, and also add sometimes an enforcement agency on top of that. To do so, to go down that second route, they would need to have a clear understanding, the states would need to have clear understanding of the competences of both sides, a use of standardized forms and procedures. For example, when we talk about divorce for non-state endorsed religious adjudicatory fora of the money, how much one pays for these services. And obviously, and the most important one is to establish routes of communication between religious instances and family law. I think that regulation is probably not the only, probably not a perfect solution when it comes to regulating Sharia in Europe, because it relies on the preconditions that women know when to address which instance, so when to go to state court and when to go to a religious forum. It relies on the precondition that regulation would force internal reform of anything that is, too traditional, too conservative, too inegalitarian, but we don't know that this will happen. It doesn't solve the problem of social pressure. So heavy regulation cannot outlaw shunning or ostracism. And then prohibition of Sharia fora, if we go into the extreme scenario where states prohibit them, probably will create even more violations of fundamental rights. And in terms of conclusion, in this paper, I recommend that instead of focusing on regulation, one should perhaps look more closely on the mechanisms that individual and collective religious groups understand as being compulsory for them and why they choose to act in the way they act. Understanding, however, that regulation is not an anomaly, but a way to manage transformation within groups and between the majorities and the minorities. What is interesting, however, as a finding is that the state in both scenarios, whether it regulates and whether it doesn't, will probably, and whether it intervenes and when it doesn't, it will probably end up violating a certain number of fundamental rights. So ultimately, and that will be my final point, is that we should focus on the balance between religious autonomy and differentiation between religion as such and the state, but using contextual state regulation and emphasizing the links between religious law and civil law, because most of these cases obviously concern family law matters. And I thank you.
Okay, thank you so much, Kayake, for this very interesting presentation. On my part, I agree completely with your conclusion about the necessity of balancing. Only my question is, how much space civil law tradition, civil law experience has, from this point of view, has given to the necessity of translation and in between religious law and secular law. And at what extent this translation has not carried out too much on the normative level, rather than on anthropological and semiotic level. So has to mine and bring to the surface all the possibility to interpenetrate the semantic potentialities and axiological potentialities of the basin of sense, enshrined in both civil law, secular law tradition, that is, if we consider in a defective way the secularization effects on the legal tradition of Western legal systems on one side, and the anthropological basins, the anthropological resources that we can mine, we can excavating from the religious semantics. I think that from this point of view, our experience is still too much defective, I think. But I completely agree with you about the necessity of balancing and avoid this antagonistic, polarized way of representing things, and by working on this sort of identitarian conflicts and attitudes. Okay, thank you so much. I think that we now can open the discussion. And of course, I invite all the attendees to raise their virtual hands so that we can start with the discussion if there are some questions. Right. I don't see any hand. There is someone that wants to contribute to the discussion among the 14 attendees to this very interesting, from my point of view, session.
Alessandra wants to ask something.
Okay, yeah. Okay, perfect. Go.
It's not really a question, it's just maybe an insight for Kyriaki, because I was studying Sharia courts also, and maybe I can think about we can think about the fact that, for example, in the UK experience, I think that they find some some field of reasonable accommodation, they call it, in the sense that the Sharia courts and the decision of the Sharia courts and council have been qualified under the umbrella of the Arbitration Act. And in this way, the final decision of the council can be also enforced by UK courts if, of course, it's coherent with the common law and the main fundamental principle of the legal order. So they are finding, in a certain way, a path, of course, but there are many problems for the fields of family law and religious marriage that you have mentioned, because especially in marriage and divorce, there is the problem of religious marriage, which has no civil effect. So what they call limping marriages. And in this sense, I think that you mentioned the fact that mainly women are making recourse to Sharia council. Do you think that this could be also because the fact that they are afraid of the social stigma that can come from their community? I mean, when we are talking about Sharia council, this means that in these legal orders, the community is quite, I would say, organized. It's quite institutionalized in a certain way. So the force, the strength of this community also in guiding individual life, it's higher than if you look at the single person, at the single story and individual. So probably the experience of the UK, do you think that can be imitated or transferred in other legal systems, such as the Greek one or other one? I don't know, because in Italy we couldn't.
Chair, do you wish me to answer?
Yeah, for me.
No, I'm asking permission to answer.
No, I don't see other hands. I think that you can answer now.
Okay, thank you. 2 points, one methodological and then a few thoughts about the substantial aspects of the question. Methodologically, what brought to my mind the 2 cases together was the role of the state and how the state deals in, with a very fundamental difference in the first case when it recognizes a minority, and in the second, a religious order, and then when it doesn't. So obviously, otherwise, sociologically and ethnographically and historically, the 2 cases are not entirely comparable, even less from a point of view of scale. I mean, the community in Greece is like maybe 120,000 people in total, and that's all. And even within that, it's a very fragmented, community. You have different distinctions. So what I wanted to see is how the state reacts into these different scenarios. And from that point of view, when it's called to manage diversity, religious pluralism in this case, I didn't see much difference in the state's reaction, to be honest with you. There is the tendency to keep away, to stay out of it as much as possible. And I suspect that's the Italian version of the deal as well. And obviously, religious is a very difficult, identity marker to manage, especially at that scale. So what I wanted to see and what I wanted to answer is more or less, where does the state stand in all of this? And what is the expectation that, we should have as super diverse societies from states in the Western context? For Greece, there is the added problem that I told you, that I mentioned, for the politics of hostility, of historical hostility with Turkey. And then it's also a question of national identification, not only religious identification, because there's a difference between old and new Islam in Greece. Anyway, so that's one point. And then substantially in terms of the UK example, I did mention that social standing and peer pressure are things that obviously matter. It is also related to what I mentioned as being, the notion of consent and to what extent you really agree to do what they tell you, or what you end up doing by going and approaching these fora. But I have a sense, and I'm a lawyer mostly, not an ethnographer or an anthropologist, that the picture is much more nuanced than that. I don't think it's just a question of peer pressure. I do think that, especially in the UK, where we have several generations of Muslims, we are looking at a gradual transformation when it comes to agency. And we should start thinking about why people go there. The Shahar and Ben Habib context is important, is essential. But I think today it's part of the story, it's not the full story in terms of research. So this is what I was trying to convey. So otherwise, I do agree with you. It is not possible to, transplant models and decisions. And I'm not even sure that this is a completed process, even for the UK. Even if the law changes, even if the law changes, even if there is a formal recognition, you cannot entirely, the state is not entirely attuned to understanding what is happening on the ground within these communities, apart from like the very broad, tendencies and movements and trends. So I think we should force the coexistence, to go back to the chair's initial comment after my presentation. I think we should go back into looking at the imperfect scenarios we can come up with in the understanding that conflict is unavoidable. And in the understanding that, law is a social phenomenon, as the way I see it. It is not self-sufficient, it's not autonomous, and therefore we cannot expect miracles from it. So I'll stop here because, I shouldn't monopolize. Thank you. But thank you for the comments.
don't know. Let's see. Krista, have you raised your hand? So you can, okay,
Thank you.
raise your question, please.
Kiriaki, unfortunately, this is also for you because this is what I know a little about. As you know, that we do have religious organizations that operate in a non-state sphere in South Africa, and the decisions that they take are binding inter partes. So people sort of are bound by them in that community. So it's mostly women that's not happy with the rules that are being applied to them, and they go to the state courts, and normally, because they can't afford it, with the help of NGOs. So how are you going, if you endorse those institutions, if the state endorses it and say, well, you are now part of state law, will somebody still have that option if they don't get the respite in those institutions to go to a state court for protection?
I don't think that in the European scenario, we understand endorsement as a fully fledged, at least not yet, as a fully fledged acceptance of these kinds of decisions within those religious fora. In the Greek case, for example, as I explained to you, there is a requirement for a decree of enforceability, so a compatibility check, if you want, with the constitution. So by virtue of the fact that we cannot speak of a full legal fusion, so it's, you know, a full part of the official legal system, I do foresee, if I am in a position to foresee, that these women gradually, slowly, too slowly, if you ask me, will realize that they have the choice, and the choice is a matter of what do you want to achieve with the kind of decision. I have in mind a very particular scenario, which is the Israeli case, and we've discussed this in the past. So I think that there it is very obvious that people are very much aware as to where they want to take a case and how and why they choose that particular forum, because they know what to expect from it. What is more problematic for the religious forum, and I take the criticism that you voice, and the point is that these forum, as far as I know and from what I've read, are not consistent in their findings, because there is so much, you know, non-uniformity within those groups in Europe. We are having trouble to, you know, foresee. And these community members are also the ones primarily affected by this lack of consistency. So I think the choice will remain, but I'm not sure to what extent it will always be a meaningful choice, if you see what I mean.
Thank you.
I don't see other hands. I'm sorry. Okay, David Summit. Okay, you can write your question.
Thank you. Yeah, well, I have a question primarily for Ivan, but also for the other members of the panel, which is, you know, when I was listening to your presentation, Ivan, I kept thinking, you know, that in a way, many of the obstacles that you cited to realizing human rights were specific to Malta's mixed jurisdiction, in the sense that we have rules which come together from the common law and the civil law world, and they tend to come together in a way which limits the enjoyment of rights rather than making it more easy. In the sense that you have to go through a kind of a labyrinth in the civil courts, which have an approach which is much more civilian in nature to exhaust the ordinary remedy. And then when you're given access to the human rights remedy, you basically have to go before a special court, even if it is the same court, which changes its jurisdiction. So the first hall of the civil court first has a sort of general civil law jurisdiction, then it becomes a specialized human rights case at the same court. So I'm just wondering whether, you know, to what extent mixed jurisdictions, but also legal hybridity and legal pluralism more generally, complicates access to human rights. Therefore, whether, there have been any studies also specifically relating these two factors.
Can I answer? Okay.
You can answer, Kevin. Thank you.
Okay. Well, in my opinion, I mean, especially looking at Malta, mixed jurisdictions don't work well, especially when they are mixed without a coherent way, so to speak. I mean, obviously, the procedure is common law, substantive law is normal civil law, as in Italy, France, etc. I mean, the court system works more like a common law system, yet we are enforcing civil law rules. And these do create frictions and delays, which means that Article 6 of the Convention will probably be infringed even more often. Again, from my experience, one of the delay for in the Constitutional Court was simply because of a procedural issue. Okay, the excessive importance given to oral hearings as opposed to written proceedings and human rights proceedings, as they are mainly points of law. I think written proceedings should be the rule. I mean, I'm not saying there should not be oral hearings, but oral hearings should be limited. Normally, points of law, it's useless arguing in court because you can be much more scientific and specific in writing than in a court of law, especially in a judge who is jack of all trades. Okay, and the lawyers are jack of all trades. I mean, sometimes lawyers simply go to court to make noises and to sow doubt in the other party, rather than instead, for example, arguing on the substantive law. I mean, so this is the problem of our case. In the European Court, I think at the level of Strasbourg, things have always improved because they reduce bureaucracy. For example, even how you file an application today, there's a standard formula. So you just don't write a letter, you need to tick the box. So it makes easy. And filing a case could be done even by a non-lawyer, technically, and then a lawyer obviously would be needed by submission. Then another point, which I haven't mentioned in my presentation, which is equally important, access to justice require a good legal aid procedure. In my country, legal aid is almost non-existent. At the Strasbourg level, the court obviously is free of charge and can appoint you lawyers if you are not in a position to defend yourself. But as we have seen, even another case involving Malta, which I'm sure Dr. Zambit is fully aware, I mean, the Maltese legal aid failed completely to service the client, and then it had to be sort of, I mean, the University Law Clinic to step in, training the students, and basically have done a much better job than the legal aid service. So the university is not there to replace the legal aid, but I mean, these issues keep coming all the time.
Definitely, and
obviously, I think at EU level, then we have similar problems to Malta because the EU legal system is itself mixed. I mean, and that might create some issues, but anyway, I mean, ultimately, nothing is perfect. But from my recommendations at the end, I'm sure that technology, more investment, more written procedure will make things better.
Thank you.
Thank you.
Okay, thank you, Kevin. Krista, do you raise again your hand?
Yes,
Yeah,
please.
okay.
I want to ask a question for Volvia this time about populism and the Constitution. I remember more than 20 years ago when South Africa got its first democratic constitution, the government made quite an effort to distribute the contents, especially the Bill of Rights, in a very accessible populist way. And so the people in South Africa are very aware of their rights in terms of the Constitution. and they will very quickly tell you, well, this is my right in terms of the Constitution. And I've been wondering what the influence of that was on your responsibilities, because our Constitution is not like the Indian Constitution tells you, you also have duties. So people sort of, this whole populist idea of my rights sort of negate the idea that you also have responsibilities in terms of Constitution. I mean, for every right, there's a counter duty. The one has a right to privacy, but the other one has a duty to respect that person's privacy. In your studies, could you come across that where populist ideas also forget about the responsibilities that you have in terms of the Constitution, or does it just focus on your rights? You're still muted.
Okay, thank you.
Yeah, I agree with you.
Yeah,
I think that the element of populism is this, to subvert the Constitution, because the Constitution is a limit to the populism, above all in a particular country, because there is not, or probably is implicit, the idea of duty. It's not so explicit. So probably the ambiguity of Constitution create also the possibility to spread the populism. If you can see, we have the old Constitution, Italian, German Constitution, USA Constitution, that have a good possibility to give to the populist to subvert the Constitution, because probably the ambiguity of the written Constitution give this different possibility to give a narrative, a counter narrative about fundamental rights. This is my opinion.
Thank you.
Thank you to you for the question.
okay. Are there other questions? Let me see. I'm scrolling. No, I think no. So if it's so, I think that we can conclude here our session. Thank you. Compliments to the speakers for the very insightful presentation. Thank you to Fulvia, Ivan, and Kyriaki. Then Kyriaki, we can continue our discussion offline with it in another place. Just because your topics are my topics, so I have for precisely this reason I'm very interested in this. Just only one warning. I'm afraid that the creation of different jurisdiction could transform in a self-fulfilling prophecy, just because they improve the formal differentiation and the differentiation from a sociological point of view and psychosocial point of view. So I think that the translation translational task is to carry out by merging legal dimension and anthropological dimension. I think that this task has not already accomplished, if any, but I don't know if it's what tempted.
We agree.
Okay, right. So thank you to all of you. And so I think that we can pass to the final session and the general session. Thank you. I don't want to take out time to that. Thank you again.
Thank you.
Bye.
Thanks. Bye.
Thank you. Bye.